She's my age. Did she tell you that? How would you feel if your father married someone who was your age?
You, however, had time to hide the gun, didn't you, Chutney? After you shot your father.
I didn't mean to shoot him. I thought it was you walking through the door.
Order, order. Order.
Oh my God.
Oh my God. Oh my God.
Yep, oh my god. But let's pause and rewind for a bit, shall we? Right, before all of this cross-examination started, how do you think this whole proceeding take into place? And who initiated? But most importantly, where does the taking of cognizance of offense happens? Plus, is the magistrate bound to examine the complainant after that? Exactly. Now, all of these issues will be discussed in this video. Enjoy!
Initiation of proceedings come under Part 6 of Criminal Procedure Code to be specified under Section 128 to Section 137. Concerning this, it is significant for us to know on how the magistrate initiates proceedings by looking into the cognizance of offence by the magistrate. There is no clear definitions of cognizance in Criminal Procedure Code. The definition of the term cognizance has been discussed in the recent case of Peguam Negara Malaysia versus Muhammad Qasim bin Abdul Hamid, where the Court of Appeal has referred to the definition given in Black Law Dictionary as given below. Cognizance means jurisdiction, or the exercise of jurisdiction, or power to try and determine causes, judicial examinations of a matter, a power, and authority to make it. In a more literal way of saying, it means becoming aware or getting the knowledge of any such offences. Combining both together, it will be understood to mean as the court clothes itself with the jurisdiction to inquire into the matter that comes into a knowledge and further contemplating whether there is a possible action against the person complained of. However, cognizance is something prior to but does not necessarily mean the commencement of judicial proceeding against anyone. The term taking cognizance does not imply any formal action, but the process begins when the magistrate seriously considers the alleged conduct of an offence for the purposes of legal proceedings.
Assalamualaikum and good day. My name is Nasrin Nabihah and my metric number is 272244. So for my part, I will be explaining on the concept of cognizance of offence. So before that, it is important to refer to Section 128 of the Criminal Procedure Code. So under this provision, it has stated that a magistrate may take cognizance of offence by way of 4 circumstances, which firstly, by way of complaint, second, by way of knowledge or suspicion that an offence has been committed, third, by a warrant issued by public prosecutor inquiring into an offence, and lastly, when a person is brought before him in custody. However, in this part, it is important that under paragraph B, whenever a magistrate took cognizance of offence by way of his own knowledge or suspicion that an offence has been committed, in the said case, the accused is entitled to require that his case be tried by another magistrate. Now, we'll move on to the second part. So in this part, we will mainly focus on the limitations of cognizance of offence. So Section 129 of the Criminal Procedure Code in overall highlights that there are certain crimes mandatory for the court to obtain previous sanctions by the public prosecutor, except in cases where the complaints are made by the public prosecutor themselves. Next, Section 130, 131, and 132 of the Criminal Procedure Code highlights that there are particular persons required to file a complaint under certain crimes. So what about the next stages? So the next stages, after a magistrate has taken cognizance of offence by way of complaint under Section 128, the next stages are outlined under Section 133 until 137 of the Criminal Procedure Code. This will be further discussed by my team members, and the answers to this assignment will be thoroughly explained.
Before diving into the nitty-gritty of the questions given, it is essential for us to know some fundamental procedure after the magistrate took cognizance of the offence. First of all, a date shall be set by the magistrate to examine the complainant. Besides, a written notice shall be served to the public prosecutor at least 7 days before the examination date. Clear date here means a complete day, without counting the starting day and the finishing day. In this notice, it must contain the particulars of the complaint received under Sections 1 to 8 of the CPC, and the date of the examinations of the complainant. Aside from that, the complainant will be examining under oath. All the substance of the examinations must be reduced in writing and signed by both the complainant and the magistrate. Examinations of the complainant is not a mere matter of formality. It is like a preliminary inquiry, but care must be taken not to inquire into the case for the defects. Sadly but rightly, non-examinations of the complainant is curable irregularity under Sections 422 of the CPC, if there is prima facie and non-occasions with failure of justice. What happened if the magistrate found there were no sufficient grounds for proceeding after examining the complaint? If that is the case, he may dismiss the complaint and the result of the inquiry, if any. To sum up, the object of an examination after Sections 133 of the CPC is threefold. Firstly, to ascertain the facts constituting the offence where they are not given in the written complaints, or to clarify the doubtful points therein. In such case, the magistrate holds the duty to explain the procedure and ask the complainant to mention the particular charge he intends to make. Secondly, to separate unfolded from substantial cases at the outset and to prevent innocent persons from being framed, as been illustrated in the case of Dato Seri Samibelu versus S. Nadaraja. Thirdly, to assist the magistrate to judge if there are sufficient grounds for proceedings.
After knowing the procedure as well as the object of examining the complainant, now let us move on to when is the time the magistrate needs to examine the complainant. Is it before or after taking the cognitions of the offence? So actually, there's a hot debate on the questions whether the magistrate was bound to examine the complainant before or after taking the cognitions of the offence. And this is discussed in great detail in the case of Tan Hock Wan versus PP. So the short answer given by this case is that the magistrate is not bound to examine the complainant until after he has taken the cognitions of the offence. So you must be wondering, why is it so? Follow me and I will now bring you to look upon the rationale behind this in the ahead discussion. In Tan Hock Wan case is concerning that the appellant has made a complaint regarding assault and criminal intimidations by the police officer. However, the magistrate directed him to launch a police report rather than examine the appellant on oath as required under Section 133. Thus, the appellant appeared. So the Section 133 discussed in this case is the sections before the amendment taking place. But never mind, what we shall look upon here is the wording of when a magistrate takes cognitions of an offence on the complaint, where we also have the same wording in the section after the amendment. So from this wording, it's plain and clear to see that when the magistrate takes cognitions means that after the magistrate has taken the cognitions. So it is definitely not any time before it has taken the cognitions. Also, the court viewed that it is ridiculous if it is interpreted that the magistrate shall write after or immediately after taking the cognitions to examine the complainant, due to the fact that he should discontinue other work scheduled for the day, which might be more urgent, and proceed to examine the complainant right away. Hence, this section has then amended to set the date to examine the complainants. So coming back, meaning to say, only after the magistrate has taken cognition, he shall then examine the complainant on oath. So if he has not yet taken such cognition, he is then not bound to examine the complainant on oath. Hence, the answer to the questions depends on whether the magistrate has taken the cognition. So here comes another question. That is, what is the time a magistrate is said to take cognitions? So this will relate back to what has been explained by my member before. Taking cognitions means taking notice of an offence. So in the case of Tan Hock Wan, the court viewed that it would include the intentions of initiating a judicial proceeding against the offender or taking steps to see whether there's any basis for filing a formal charge. That is to say, it's not merely a magistrate learning that some offense has been committed, and in fact, it is a time when the magistrate decides to take actions against the person accused of committed the offense, and not when the magistrate is first made aware of the commissions of the crime through a complaint. So if the magistrate is using the discretion for anything other than a proceeding, such as ordering an investigation or issuing a search warrant for investigation, this cannot be said as taking cognizance of the offense. Hence, this clearly implies that a magistrate is not bound to examine the complaint on oath unless he has first taken the cognizance of the offense. And pertaining to whether there is a taken of cognizance, we shall then look at the magistrate intention. In Dato Sri S. Sami case, also opined that cognizance is nothing more than a preliminary decision in response to an allegations where an offense has been committed by someone that the allegations ought to be looked into. That is to say, only when the cognizance is taken of the complaint, sections 133 of CPC comes into operations. Also, take a look on sections 1 to 8. The word may take cognizance means that it is the discretion of the magistrate to take cognizance and is not mandatory. So means, if the magistrate does not have the intention and see no point to initiate the proceeding, it can be said to be a waste of time if they continue to examine the complainant. Therefore, again, it shows that the magistrate is not bound to examine the complainant as this is their discretion. That's all from me. Thank you.
To conclude, it can be derived from the discussion that a magistrate is not bound to examine the complainant until after the taking of cognizance of an offense has taken place, as he is not bound by the law to take such cognizance right after the complaint was received. Hence, so long as the cognizance of offense had yet to occur, the examination of the complainant shall not be done. The rationale being that taking the cognizance of offense signifies that the magistrate has the intention to initiate a proceeding. Thus, such a complaint must be clearly determined as to whether there is sufficient basis to proceed against the accused person.